Hello, chat. So, waiting for the court feed to go live. So, we've just got the Honorable Judge Kevin Farmer up here on the screen, his YouTube channel. I'll drop a link to you guys. Judge Farmer. And quick housekeeping. Atlanta Community Press Collective, who's really done a lot to, this isn't the only issue that they cover, but last night I was able to go back and they had footage of Surishada Jimenez in court arguing against the mistrial when Isla King's trial started for the second time. They had interviews yesterday. Oh, I'm in the channel feed. But they had interviews with different attorneys and defendants yesterday. Here's some from a day ago. I think this was 2 days ago. It's saying 1 day ago, so who knows. And they only have 976 subscribers, which is kind of blowing my mind. So they are pinned at the chat. I would love to see them get to 1K. Because aside from them, it looks like Judge Farmer started to stream some of his proceedings. He's got these two things that are... Let's watch this 5-second one. Is this like an intro video? It's 5 seconds long. What is this? What are we doing? Oh, we just made a mistake. He just went live for 5 seconds 10 months ago. An elections hearing, and then everything else is within the last week. So maybe he deletes some of his feeds. But besides his feed for this trial, it'd really only be Atlanta Community Press Collective. So we'll keep refreshing, looking for a feed. Let me drop their link again. We'll call them ACPC. If we could get them to 1K, that would seriously be awesome. And likewise, when Sylvia goes live, Sylvia today will be in Fulton County Court, but she's going to be over at the Gregory King hearing. So if you guys are interested in following that, I'll look for any updates, but we'll be watching what's going to happen with this count too. But just so you know, Sylvia will be in the courtroom for that hearing, and I still think she's the only one with a Rule 22 over there. So, quick summary of where we are. So, Stop Cop City RICO, 61 co-defendants. They're segmented into groups to be tried in parts, like 4 or 5 at a time. The first group invited a special guest, Don Samuel, to come make arguments on general and special demurrer. Some other attorneys made demurrer arguments as well. But really, when we had Attorney Andrew Hall get up yesterday and start arguing about, did the Attorney General have authorization to bring this prosecution forward? Judge ends up agreeing that I don't find that the Attorney General had authorization to bring this prosecution forward. We're going to argue count 2 today, the constitutionality of count 2. But yesterday, he said he's probably going to dismiss the racketeering, count 1, and then count 3, the arson. And that would whittle this case down to just 5 remaining defendants if that stands. He said that he would issue a certificate of immediate review so the state could appeal that decision. So that's going to be, we're going to get some appeal stuff to follow there. And that's the short of it. I think that's the quick summary. And maybe ACPC will also do a feed today. They were supposed to start at 9:30, who knows? But we'll do a little roll call in the chat. So we've got Amanda Robinson here. Good to see you, Amanda, bright and early, #1 in the chat. Neri is here. Neri, thank you so much for your insight yesterday too, here and over in Jim's stream. Tons of context that you bring to the chat. Nem, good morning. We got Mark. Good morning, Mark, in the building, fellow Floridian. Corky, good to see you. Trakeisha, I feel like I've spent all day with Trakeisha yesterday, going over to Jim's. And Jim's surprised yesterday, guys. So Jim finally got his channel monetized. Trakeisha, Factual Lie, myself, and Nick Starro, we all went over there and tried to gift a bunch of memberships. YouTube didn't gift them out. Like, the payment went through, but nobody turned green. Nobody was assigned a gift. I, after like an hour, got YouTube to refund the gifts I made, so I'm going to end up re-gifting. I'm going to gift one at a time to see that it goes through. But the next time Jim goes live, that was a surprise yesterday. It didn't work. It was the worst grift ever. Very characteristic for Jim. But we're going to redo that. So trying to give out 50 gifts over there when we see that YouTube's actually functioning. And I don't know if it was just his channel. I don't know if that's a global thing that's happening. Let me see. Let me test it out. Let's see if you guys get assigned these 5 I'm pumping out here. All right, so Sirach, Autodoc, I see you guys getting gifts, so it's working again. So either it's Jim's channel or they just didn't like us yesterday. But we will redo that whenever Jim goes live again. Shell says, uh-oh, I'm number 13. Yeah, hit that like button, you guys. And you never know. Sometimes if you don't refresh your screen, the like button isn't the right number, so it might not actually have been 13. But Shell also says the prosecution broke my brain yesterday. Yeah, that was a lot. All just to lose, too. And look, they're going up. Thank you for subbing up over there, guys. I think they'll hit 1K by the end of this stream, and I would love that. What if we just get a message like, Judge Farmer's like, this is stupid, I can't do this, guys. Hey, Anisha. I'm in Brevard. I'm in Cocoa Beach. And speaking of Brevard, yesterday I mentioned there was a mistrial declared. This is over in, they're calling it a Melbourne, Florida case, but there's a town here that's like being built up. It's really nice. It's like teenagers all ride around in golf carts around the shopping centers. It's kind of crazy over there, called Vieira. But every time I drive through there, they're like building more and more and more. They're getting a Whole Foods. They're like, it's like the fancy spot of Brevard County. But there is a trial going on, or kind of having to restart, being tried. Like, they're my neighbors, the Vieira courthouse. So maybe I'll go down for a day. We talked about it real quick yesterday. Florida v. Erica Dotson. She has a co-defendant, her boyfriend, Jonathan Mans. Is it Jonathan Mans? I don't remember what the... Joshua Mans. So, long story short, finally found out why a mistrial was declared. All we heard was a discovery violation. But I said I would get more details. Well, the defendant took the stand in her own defense. So she's on the stand, and the prosecution is asking very specific questions. They were something to the effect of, not verbatim, but, and did you strike your child across the head? Oh, and then did you hit them with this instrument? And then did you do, and they were very specific questions. So the defense asked to speak to the judge, and I guess they cleared the jury out. I'm not sure, but I would assume. The defense says, look, we have concerns because these questions are extremely specific, and we think that there might be a discovery violation where they're getting these questions from some other information, someone that they spoke to, and they didn't turn that over to us. And the defense was right. So it turns out that the state interviewed, and this is where it's crazy, Dotson's boyfriend, the defendant's boyfriend, and co-defendant, Joshua Mans. The state interviews him. Do you think that that's something that the state should turn over and tell the defense about? He's not just like some Joe Schmo that I didn't see anything. He's a central piece of this trial. You also indicted him, and you have an interview with him, and you don't think that that's important to disclose to the defense? The state goes on to explain that, well, we didn't plan to use that interview in this trial against Dotson, and we didn't plan to call Mans as a witness. Okay. But yet you're clearly using information he told you in that interview and blindsiding the defendant and the defense counsel by asking questions derived from that interview. So the judge calls a mistrial, and they're supposed to have hearings to reset another trial. One news outlet said by the end of the month, another said by the end of October. So I'm not really sure on the specifics of that, but now I'm kind of invested. And Joshua Mans has a hearing today. So now I'm invested in this little local case. But that was an update on the random Florida. We actually saw a mistrial for a Brady violation.
You're saying, come on.
but we're just gonna get a rescheduled trial, which I think is kind of crazy. Also, shout out to Credence and Mikey in the building. Thank you for the super sticker here. Good to see you. You guys also, I know a lot of you guys like to watch, quick cases, cop chases. I love his slogan. Let me get the link there, you guys. Definitely sub up over there. And he does reaction commentary too. It's not just like the plain, you won't have to be watching it by yourself all the time. But definitely worth it, because when I go away for a week and you guys are like, Kat, where are you? We're bored. You could spend some time with Mikey. So big thank you for the sticker. And Jay Money dropping 10 gifted memberships. We're going to get you in the banner here. Very big thank you. Thanks for showing that the feature still works. The gifts are my favorite feature on YouTube, so that was kind of sad, a letdown yesterday when the YouTube just decided to break on me. So let's get some love in the chat here. And apparently none of these are popping up when I touch them. There we go. Let's get some love in the chat there for Mikey and for J Money. And then also shout out to Tyranny for you for turning green. Love to see it. Just so you guys know, when you turn green here, you're part of this gang, so be careful. So with that being said, we're going to get into this hearing. We've got them firing it up. We'll see what's going on. And really the purpose of today is to look at count 2. Volume. Okay, volume's a little crazy. And no CCs over here. I'll keep looking for closed captions.
Yes, we don't even have to look at the indictment to deal with that. If the legislature didn't pass this statute constitutionally, it's void. There's just no rules in the past. There's no law. That issue, and I'll admit, we should have filed that as a demurred account in the rush to meet Judge Adams' deadline and then
all right,
back in May. We just missed it, but kind of like the way.
Chat, let's vote. Kevin Farmer, the judge, has captions on his feed. We'll be looking at people's noses because it's a Zoom feed. But they do have closed captions, so I think that could be helpful because I have it boosted and it's still really quiet. So I think that might be the move, you guys. If you guys want to change back to the full screen, let me know. We'll make that happen. But I think this is a bit more accessible for everybody.
Court took up yesterday. Right? We don't even have to look at the indictment to deal with that. If the legislature didn't pass this statute constitutionally, it's void.
Maybe not.
If they didn't follow the rules in the past.
There's no law. That issue, and I'll admit, we should have filed that as a demurred account 2 in the rush to meet Judge Adams' deadline and then Your Honor's deadline back in May. We just missed it. But kind of like the way arson was preserved in yesterday's argument, even though that was only an attack on count 1, same concept, same logic here. The challenge to the domestic terrorism statute in 22 is a very clean, relatively fast argument. I told Mr. Fowler if we did this, we'd certainly be done by lunch. I probably shouldn't say it out loud, but if we just take up 18 and 22 today.
Not if the state argues.
I think that just ties this up as efficiently as we possibly can and then save the demurred account 3 for later, considering the state's likely to have to re-indict that anyway.
Which, yes, they obviously have the ability to do. Win, lose, or draw. I mean, they go across the street and win. Then we come back and I look at the special demurrers. I either find those special demurrers, I either grant them if I don't. If I don't, then they're good to go. If I do grant them, they get to go, get a letter from the governor, get authorization from the governor, walk back into a grand jury and do the whole thing again. So I think we all recognize that, the fat lady is not singing. It ain't over.
But to the court's question, I don't want to say that the other 4 don't want to be heard, but we did meet yesterday. They're on notice that this is happening.
Yeah, well, they're
not docketed.
Yeah, notice is an iffy word, and I want to make sure we have a good record, and I have no reason to disbelieve, your assertions to the court. regarding your conversations with co-counsel, but it's a pretty big deal and I kind of want them on the record. And somebody's here for one of them?
That's here for field.
Okay.
You could say there were some attorneys that maybe not understand.
All
Can I
right.
just get them on? Just get them on real quick. You're saying get them on?
That was my bad.
Or-
What did I say?
Yeah.
I was checking to make sure they weren't just gonna call it quits.
In the Zoom room,
Mhm.
and so it's possible they could be those attorneys.
I don't see anybody in there.
Yeah,
Are
no
you
laughing in
waiting
court,
for them?
They
Autodoc.
were in the waiting.
Stanley Cohen's arguing 22.
See the gentleman in New York?
He is.
Okay, gotcha.
Oh, gosh.
Yeah. Okay, I want to get stuff on the record and as I said, I don't have any reason to doubt your assertions. But it's kind of hard for them to waive their presence while they're not here.
Well, I don't think we're waiving their presence. In the same way that the court reached a conclusion on Mr. Carroll's motion yesterday, or will be reaching a conclusion next week, we'd be doing the same thing.
And notice of this week's hearings did go out to all attorneys, to all defendants.
Ms. Hyman, who represents Ms. Defendant Murphy, was present at portions of this week.
Yeah, my jury box got a lot emptier.
Mr. Butterfield, who represents Ms. Geyer, I believe, has not been present. And who's the fourth?
He represents Mr. Ferguson.
Oh, Mr. Ferguson, sorry, Mr. Butterfield for Mr. Ferguson, Ms. Geyer. Oh, Ms. Kaufman has not been here, but certainly all were
Shout out to Ms.
provided
Kaufman,
notice of
Rachel
hearing.
Kaufman.
My point is, the court reached a conclusion on counts one with respect to 4 defendants. It'll influence all of them. The same thing is going to happen on count 2, whichever way the court comes down. These are, constitutional issues that are not specific to any particular.
But here's
defendant.
what as I said, I take the slippery slope all the way to the end. You argue, I rule against you. These other 4 folks go, hey, whoa, I didn't get a chance to make my argument. I don't want that, because you are the basket that all the eggs are in. And procedurally, that makes me nervous.
And I don't know if I'd say it's a flaw. It's a reality of every issue in this case with.
Well, getting 5 in a room is a lot easier than getting 61 in a room.
Sure, I just mean that, so I don't know if you've handled the death penalty case. The Unified Appeal Procedure has this provision that allows for the
I
court to
have.
send.
Neither as a defense lawyer or DA or judge.
So one nice thing about the Unified Appeal Procedure is before trial, every pretrial issue that's been raised, the trial judge can certify for interim review. That's what we need in this case, but it's not practical unless you bring all 61 in, because until you bring that 61st defendant in, you don't know if there's going to be something raised down the road that changes the way you're thinking about how we've argued other stuff. I mean, it's just how it's going to be. I don't have a strong position on this. If we want to get the other 4 to confirm that they'll adopt this argument for purposes of a cleaner record, we can do that, or the other 3, because 1 is here.
And I apologize, counsel, for interrupting. Just one other, and I'm not trying to throw another problem on top of it. It's not just counsel being here, but the defendants would have to waive their right to be in court as well, because they have that right as well, not just to be here or on Zoom. But that is something that I don't want to bypass. And then, of course, later on down the road, that would be a constitutional and structural error that we'd all just be right back here all over again.
Somebody was ineffective by not telling me I could come to court and argue, pick your argument.
So if we do want to do it, I think that if we want to do it today, I think that the way we would do it is we would just be clear that we are cabining this argument to Mr. Carroll and Mr. Carroll only through Mr. Schwartz. And then if the other lawyers wanted to argue that down the road, they would just have that argument later on down the road in a similar hearing. Whether the court wishes to do that for the purposes of judicial economy, whether that's sent so that we can send it up with the other issue today, or if you wish to combine them together at another hearing on another day, and that's the court wishes to go on judicial economy that way. Either way, we're still using the term judicial economy, and I'll leave that up to the court's discretion. And I hope that made sense, Your Honor.
It's the same issue. If we take any other,
Did all five folks file the exact same motion?
I believe so. I have to look to be sure, but that was the plan.
Who is the author of said motion? I know you're good at copying.
On
and pasting.
count.
They should have done the
I can't
Harvey
write,
rule.
Judge.
I believe you.
On 18, the original author was. It was.
Okay,
On 22, the original author was Mr. Cohen and Mr. Sheffield, which is not a five defendant. It's not a count two defendant, but
okay.
it's attack on that statute. And I don't think that all five did adopt 22. I think that's specific, maybe just to Mr. Carroll. But this is just, it's a problem we're going to have on everything. If you take a random challenge to count one, like failure to allege a racketeering pattern. We hadn't argued that yet, but we were about to, and we were going to ask the court to dismiss. And if the court did, the others benefit. If the court didn't, the other 656 aren't standing here saying, well, I didn't get a chance to argue. I mean, they're going to say that when it's their turn, but that's not a reason not to take that up this week. Same applies to these two issues, I think.
We just talking.
Shout out
I
to J
know.
Money for another
Well,
10.
yeah,
That's
there's
20.
grand
That's
total
super
5.
generous.
So,
you
and we've
so
got two
much.
of them here.
Let's update this banner.
Can I just go back and
Get some W's for Jay in the chat.
try and get a hold of the three attorneys out on Zoom?
Oh, we could also just hear y'all's argument today, and I can take it under consideration and say, set a date certain for an order. And if any of the other parties want to be heard before that date, that is their chance. They have to opt into that argument. If they don't, they're going to stand with it. So that way they're not precluded from bringing an additional argument if after they watch this or hear from it or whatever, think, oh, they missed something. Judge is going to issue an order on X date. We've got to request a hearing 5 days before that date. Otherwise, we're stuck with what was previously argued.
Makes sense.
Mr. Fowler? I think that protects everybody.
I think so, Your Honor. I think the court has good judgment in this area. I'll leave it to the court.
In this area. I understand. Okay, so 8. Oh, I'm sorry, Mr. Hetzel. What can I do for you?
Just tell me whether I'm staying or
That's right. You want to go to Cherokee County.
one might be strong, but
If you have no business here, you're, as far as I'm concerned, you're free to go. We're not going to be taking up count 1 today. So that goes for the other 2 counsel as well.
They want to see the mess.
have a good day, Your Honor. Oh, well.
Yeah, Mr. Dejanon, you, and Mr. Kazicki?
Understand, Your Honor, we'll stick around for,
Okay.
I think we can
Likewise, we'll
skip
be
ahead.
hearing-
Where's Mom today?
getting ready for our event
Uh,
this weekend.
okay.
Hope that
All right. So y'all gonna be sticking around. That's fine. But, Mr. Hetzel, you are free to head on up 575. Okay.
Stacy Zivit says, guess what day it is?
Uh-oh, guess what day it is? Guess what day it is? Huh? Anybody? Uh-oh.
We would propose
guess
starting in
what
Judge
day it
22.
Oh, wait, why is it
Just
looping?
Going by Zoom.
Don't loop. Good to see you, Stacy Zivit.
And where is, there's Stanley Cohen. Oh. Mr. Cohen. I see Mr. Cohen. Mr. Cohen, can you see and or hear us? You are on mute, sir.
I'm part of it.
Are we good now?
We are good.
Wonderful.
All right. Mr. Cohen, you're here to argue on behalf of, looks like, arguing on behalf of Mr. Carroll with regard to precluding the use of domestic terrorism as an overt act.
That is correct, Your Honor. And I want to thank you for the opportunity to participate in this argument.
Well, I don't, to the extent I can take credit for that, sure. But I think defendants get to pick their lawyers. So go ahead, sir.
Hey, Dizzy.
Thank you. Judge, I had originally planned to preface my discussion or my entrance with a discussion about the issue of overbreadth and vagueness. But given Your Honor's decision yesterday, as I interpret it and understand it with regard to subject matter, I've decided to switch around my segue into an issue, which in my brief was the final issue, but I think should be considered first here. And that is namely, and I'm not alleging any bad faith to the state, to the prosecutor's office, the AG's office, but the legislation itself, which is the grant of authority in theory to the state to proceed under section 1611(2)20. It's very clear that under the Georgia state constitution, and pardon me for moving over, it's very clear under Article 3, Section 5, Section 12, the procedure which is set in place for enacting a statute, respectfully, I think, was not adhered to by the legislature. Here, the Senate passed the bill. The House argued it was too broad because it could be used against protesters. Lo and behold, they were visionaries. The Senate adds
like this
an
guy.
intent that it shouldn't be used to prosecute free speech or assembly, and it passes a new version. The House reconsiders the bill. It makes changes. It fails. Now, under the Constitution, once the bill is reconsidered and fails, that's it. They've had the one shot, it failed. But the Senate goes back and makes some slight changes, comma, colon, semi-period, upper font, lower font. It's not a new bill. Goes back to the Senate, House, they both pass, the governor signs the bill. Now, under the Constitution, the final of 1611(20) is the same bill, the same structure, the same intent, the same language. It was rescinded more than once and then went on to pass. Now, there's a get around here with regard to the statute. And the get around is if you get 2/3 vote in support of reconsideration, it's permissible.
Sitting on a yoga
Well,
ball.
that didn't happen here. They only got 55% on the reconsideration, so it failed. So even under the constitutional procedure that says a certain statute must go a certain way in order to become law, it is violated in this particular case, leading to the passage and the application, again, without any bad reference to the law enforcement or to the state, of a law that's not a law. It's a suggestion that didn't make it. Now, what do we know at the end of the day? In reviewing the indictment, and I'm not going to dig into the indictment, but just there's something important about it for purposes of my argument. When you take a look at the 100 pages of introduction or whatever it is, 220 overt acts, you see words like promote, spread, recruit, narrate, word of mouth, take action, criticize law enforcement, criticize government, discuss, contact, delegitimize, abuse. And then when you come to the statute, and it's basically parallel. The statute talks about disable, critical, infrastructure, intended, intimidate, alter, coercion, affect, government, and conduct. But there's no definition. At its core, this is a statute which is directed specifically at speech, association, assembly, beliefs, philosophy, and without any definition, without any clarity. Now, I've spent a good chunk of my life working around issues of criminal prosecutions that implicate constitutional work. This is the first, I did handle a case in Georgia many years ago. I was a consultant, but this is the first time I had a chance to do a deep dive. I've had a deep dive to take a look at the Georgia State Constitution. It's a great document. It has a rich tradition in history going back to 1861, which is even broader as is permitted and allowed under the First Amendment. And there have been repeated opportunities and examples where the legislature and the courts have reinforced the need that when it comes to demonstrations and speech and association and assembly, there has to be specificity. And it's missing here. Article 1, Section 1, Paragraph 5, as cited by Justice Bowles 50 years ago when he chaired the State Committee on Constitutional Revision, and speaking of the standard of review, wrote, "No law shall be passed to curtail or refrain freedom of speech or of the press. Every person may speak, write, and publish sentiments, but shall be responsible for abuse of that liberty. Nevertheless, there is no saving or redeeming feature. If we make a mistake that's too restrictive, it goes down if it violates the federal Constitution." Well, and periodically this has been revisited as recently as 2022 with the Forum Act that was passed by the state legislature and constitutionally upheld. It was an act that by design was intended to expand speech protection to all at universities. In citing Ward v. Rock against racism, a Supreme Court case, the governor signed a bill that said freedom of expression, one of the greatest nation's fundamental liberties. The Georgia House Bill section 20.348, when considering speech, assembly, and association, we must apply the broadest reach of protection. The Georgia Bill of Rights, Code section 911.11.1a, the rights to petition and freedom of speech must be construed broadly. Substantial Georgia case law supports it. State v. Miller adds certain tests, which I respectfully submit are failed here. Are you criminalizing expressive conduct in speech? Does it reach within a substantial amount of constitutionally protected speech? Does it stifle expressive or protected conduct? Is it narrowly tailored? Cunningham v. State. Does it undercut broad protection for the freedom of expression? Then comes the domestic terrorism statute 16-11-220. Again, I don't mean to be verbose, but it talks about disable critical infrastructure intended to intimidate, alter, coerce, affect government misconduct. It is not narrowly drawn. It is not precise. It is insufficient on its face to give notice to Georgia citizens as to what they can do, or their visitors in the state as to what they can do or cannot do. It's vast. It creates much too much separation of powers issue where it vests in law enforcement vast discretion to police to decide what camouflage is okay and what camouflage is not okay, what tree you can sit in and what tree you can't sit in, what banner you can hold at a demonstration and what you can't. There is no attempt on the face of this statute to define between protected speech, association, and assembly and not. There is no definition or attempt to define the outer reach or limits on the statute. It's a classic example of overbreadth. And in looking to the First Amendment, as interpreted by federal courts, including this circuit, U.S. v. Stevens, Sabri v. U.S., and NAACP v. Buttons talks about to preserve First Amendment breathing space, the government may only regulate an area solely with narrow reach, with specificity, and with clear definition. And we don't have that here. There is no attempt on the face of this bill to tell me, so I can tell my kid when they're going to a demonstration, what they can wear and what they can't, what they can do and what they can't, what they can say and what they can't, what's protected and what is not. It lacks definitions of concepts. And it raises a separation of powers issue, because you've got the legislature basically saying to law enforcement and to prosecutors, you decide what you want to do. You're the ultimate arbiter. And that's not the way the Georgia Constitution or the First Amendment stands and has stood in the case of the Georgia Constitution for 150 or 60 years. The test is not the subjective interpretation of the observer or the listener, but the test is the observer intent of the speaker. Brandenburg addresses this. It's a federal case, but it had to do with a law, Brandenburg v. Ohio, where the Ku Klux Klan and neo-Nazis wanted to march in a heavily Jewish community. And though some people believe Brandenburg ultimately speaks to as applied, it didn't. It strikes down a statute because it basically says, look, the statute's not narrowly tailored. It doesn't deal with the issue of prescribing what is okay intent, what is not okay intent. It doesn't deal with the issue of what is imminent and what is not imminent. There is no specific notice to the person to give them an idea of what is permissible, and that is the friction, the tension, the problem with the constitutional clash when it comes to statutes such as this. 1611-220 fails that test. Under 1611-220, if the state has a nuclear plant, let's say, and an economic interest in a nuclear plant, and if a group of nuns, 6 of them decide they don't like the idea because it's affecting adversely the environment, they go sit down in front of the door and it causes an economic hardship for the day, no matter what their intent, no matter what their purpose, no matter what their attribution, they can be arrested under this statute and charged with domestic terrorism. At day's end, 1611-220 fails the test of overbreadth as it makes no attempt to distinguish with precision and clarity between protected and non-protected activity, good speech and bad speech. I don't know what coercion means. I don't know what intimidation means. I don't know what friction means. I don't know what coercive means. I'm a lawyer 40 years. I don't know what a 22-year-old demonstrator is going to think. Now, when you slide into the issue of vagueness, and before I do that, I just want to for a second point on the heels of Brandenburg. There is a parallel case that developed 15 years ago. It's called the Humanitarian Law Project. And it deals also with the issue of notice. And it deals with a federal terrorism law. And what do we know about it with its clash with the First Amendment? Basically, material support of terrorism can be returned when you engage in certain prescribed activity that you should know of. If you're searching for what is terrorism, what is a terrorist organization, as Humanitarian points out, you can go to the Attorney General's website, you can go to the Treasury Department's website, you can go to the State Department's website, and you can see what an FTO is, what an FTO individual is, what an FTO state is. You have notice. You also have notice of what kind of activity crosses the line. You don't have any such notice here. Now, under the Georgia Constitution, Article 1, Section 1, Paragraph 1 states very clearly, and this goes to the vagueness argument, no person shall be deprived of life, liberty, or property by due process of law. This clause also dates back to 1861. It protects fundamental rights and requires that the government afford individuals adequate legal notice and process. And in fact, it's even broader and more solicitous of those rights than the Fifth Amendment, because it goes on to talk about economic interests and reputation and issues such as that. It requires the kind of notice that's actually and clearly missing here. And yes, there is some convergence between the overbreadth concept and the vagueness concept, but by design. One deals with going out and speaking, perhaps, and the other, as here, deals with what happens when police don't like what you have to say. Now, at its core, the Supreme Court has recently visited what is the definition of vagueness. In Sessions v. DeMaio, it's very clear. It's the most recent Supreme Court decision on it. And it says, before taking away someone's liberty, there has to be sufficient notice in advance as to what can trigger that. Here, 1611-220 fails. It's lacking in fair notice. It invites arbitrary enforcement by law enforcement, which permits them to decide, again, between good camouflage and bad. It violates Johnson v. U.S., another Supreme Court decision. The question ultimately for domestic terrorism statute 1611-220 in terms of vagueness, does it provide adequate notice to the citizens as to what they can do or cannot do? Most important, does it provide plain, ordinary meaning for citizens as to where they cross the line? You know, it's in fact the fatal flaw here. The criminalization is based entirely upon the subjective reaction of the audience and not the objective intent of the speaker. Under the statute, conduct may annoy some, but not others. And to get around the vagueness issue, 75 years ago, U.S. v. Reagan, 314 U.S. 513 specifically said, the way you get around it is simple. You define mens rea. You give an actor an idea, a notice of what they can or cannot do, not with absolute certainty, but with enough guidance that you know what can be done and not. I'm going to sit down, Judge, but I think ultimately the most telling issue of the problem with overbreadth and vagueness here is the so-called savings clause by the legislature. Georgia statute 16-11-224. I call it the too little, too late clause. I've looked ad nauseum at other statutes in Georgia and federal law and then other statutes across the country. I've yet to see a legislature gratuitously add the language onto a statute that it did here. Namely, the legislature says, we respect the First Amendment. We don't wish to trample on First Amendment rights. We are well-intentioned. Basically, we want this to work well. Well, that's great. The too little, too late clause. It's wonderful that the legislature's intent was to pass a statute that would be consistent with the Georgia Constitution and the U.S. Constitution. It's wonderful that they want to respect the First Amendment. Judge, this reminds me, over the course of 40 years, I've represented thousands of defendants, and how many times when someone's been convicted or pleaded guilty, when the judge says to the defendant, what would you like to say? And the defendant gets up and says, well, I didn't mean to violate the statute. I didn't intend to violate the statute. I didn't want to do wrong. And the judge says, thank you, and then imposes a sentence. The statutory language, it's not our intent to violate the First Amendment or the Georgia Constitution or to impede anyone's rights of speech, association, and assembly. Relatively good, with due respect, Judge, it means nothing. The court is bound to take a look at the face of the statute. The court is bound under the Georgia Constitution to determine whether there is sufficient notice, whether it tramples upon the rights of assembly, speech, and association, whether it provides too much discretion to the police department and to prosecutors to go after individuals who have no notice that what they plan on doing may or may not be constitutional. And finally, to the degree that the state argues that it's an as-applied standard, it's irrelevant. given the procedural problem and how this bill was passed. Under all these terms and conditions, I respectfully submit, Judge, that Georgia Statute 1611-224 is unconstitutional because it's overly broad, it's unconstitutional because it's vague, and it's unconstitutional because it's not a real law. Thank you.
Thank you. No, thank you.
Mr. Cohen?
Yes, sir.
Okay, I was like, I hope you didn't take a powder.
No,
So you've got the vague notice, et cetera, and you're also saying it's not a law to start with because
that's correct, Your Honor.
procedurally, proper procedure was not followed in the legislature
That's correct, Your Honor. Under the
Because
Constitution.
because they had a bite at it, it didn't pass, and they violated, hold on. Was it Article 3?
It is, yes, Article 3.
Section 5, paragraph 12.
That's correct, Your Honor.
So you're saying it was rejected, and then so it can't have so to go back and have a bite at the another bite of the apple in the same session, they would have to get a 2/3 vote.
That's correct, Your Honor.
And
They didn't get it here.
okay, and you'll have to forgive me, I don't have the voting record of the legislature in evidence here. So
I will provide that, Judge.
much as the defense attorneys were complaining about offers by the state yesterday and the day before, what evidence do I have of that?
My apologies, Judge. I thought that was in, I do not have my original, I thought it was in the original footnote that referred to the procedure. With leave of the court, I will submit it to the court as soon as possible. If no later than tomorrow, I will pull it out if for some reason it wasn't in the original brief. I mean, unlike the people's argument, yet the state's argument yesterday about certain facts, this is a statutory vote. I apologize if we fail to submit it, and I will get it to Your Honor.
Okay.
That was
Go ahead,
a
Mr. Fowler.
little dig.
Thank you, Judge, and good morning again. If I can, I'd actually like to work the other way the council did, and I don't know, I don't feel like I'm kind of coming, so I need to speak up a little bit maybe so Mr. Forte can hear me.
He'll tell you if he can't hear you.
That's fair. But if I could go kind of the opposite direction, of start with overbroad, then go to vagueness, and then I'll go through the legislative history as indicated on Lexis. I will tell the court that the statute was originally passed in 2017. There is one amendment that occurs after that, and there is a more recent amendment just this past year to the statute. I'm going to go through all of those and the bill tracking history of the bill for each one of them for the court this morning.
Basically, the last one, they just shifted language from one section to another.
They did, but I just want to go ahead and go through that as well for the court, just for the purposes of the record. But if I could start with the overbroad challenge, Your Honor, the standard for for an overbroad challenge comes most recently from Williams versus Powell from the Georgia Supreme Court at 320 Georgia 221. Williams says that a statute is clear about what it prohibits, or I'm sorry, a statute that is clear about what it prohibits can nevertheless be unconstitutionally overbroad if it stifles expression or conduct that is otherwise protected by the Constitution. The doctrine of overbreadth is particularly applicable where a statute infringes upon behavior protected by the First Amendment. Conduct that has some communicative element may be regulated by the government only if the government furthers a substantial government interest that is unrelated to the suppression of free expression, and the incidental restriction on First Amendment freedom is no greater than necessary to further the government interest. Furthermore, where the expressive conduct is regulated, a statute is unconstitutionally overbroad only if the overbreadth is real and substantial, judged in relation to the statute's plainly legitimate sweep, and validation for overbreadth is strong medicine that is not to be casually employed. And that is the most recent standard from the Georgia Supreme Court. There's a case that came out of the Supreme Court in 2006 called State versus Fielden. It's Fielden. It's 280 Georgia 444. And it sort of says what Williams says: a statute that is clear about what it prohibits can nevertheless be unconstitutionally overbroad if it stifles expression or conduct that is otherwise protected. But the thing about Fielden that I'd like to point out is that the Georgia Supreme Court kind of goes out of its way in Fielden, and it takes a Georgia statute and it says, but this is unconstitutional under the First Amendment. And then it takes a Tennessee statute that is similar to it, and it says, this is a similar statute, but the Tennessee statute is good under the Constitution. And it breaks down why the Georgia statute was unconstitutional and why the Tennessee statute is constitutional under their analysis. And it's a pretty good analysis of breaking down where that line is. And so under the Georgia statute, which again was unconstitutional, and these are the sort of statutes just to kind of let the court know what it is. These are the kind of statutes that are disrupting a public meeting statute, those sorts of things where you can't run into a county commission meeting and disrupt the county commission meeting. But there are some First Amendment protections there, of course, because that can be considered political speech. So the example under the Georgia, in contrast to the Georgia statute, the Tennessee statute, which is constitutional, says that the accused requires that the accused commit an offense with the intent to prevent or disrupt the lawful meeting. It required that the obstruction or interference with the lawful meeting be substantial, and clarifies that the types of acts involve physical action or a verbal utterance. In the case of Field, and I believe that the folks that went into the meeting, whatever it was, maybe it was a county commission meeting or something like that, went in and stood silent. And it kind of disrupted things a little bit, but not a lot. They were arrested under that statute and they challenged the constitutionality of the statute. The court took a step back and they compared it to the Georgia statute. And the Georgia statute read as follows. A person who recklessly or knowingly commits any act which may reasonably be expected to prevent or disrupt a lawful meeting, gathering, or procession is guilty of a misdemeanor. That's all that the Georgia statute says. And the problem with that statute was this. It didn't require proof of a person's intent to disrupt or prevent a lawful meeting as an element of the offense, nor does it require that the committed act substantially impair ordinary conduct of the meeting. And the reason why that was problematic was because, why it was problematic was because there was no purpose for the statute that was specific to prevent a disruption of the lawful meeting in and of itself. Instead, what happened was it said, you can't do all of this First Amendment prohibited activity in any lawful meeting. So it could be two people sitting down at Starbucks. It could be people gathering anywhere in the United States. And that was the problem with that. Now, if we turn to our statute, we have to begin with the first language, the first sentence. Person commits the crime of domestic terrorism when he or she commits or attempts to commit a felony violation of the laws of the state. So we start automatically that a crime has to occur. An underlying crime has to occur. So we start there. That doesn't happen in any of these statutes that have been declared unconstitutional there. And then it goes through a little bit of language through a single unlawful act or a series of unlawful acts, which are interrelated by distinguishing characteristics. So it says not just one unlawful act, but it can be multiple unlawful illegal acts as well. And then here's where it matches up with the Tennessee statute that the Georgia Supreme Court said would be constitutional and is intended to cause serious bodily harm, kill any individual or group of individuals, or disable or destroy critical infrastructure, a state or government facility, or a public transportation system when such disability or destruction results in major economic loss. Now, I'm going to come back to the vagueness of those terms in just a moment because I have an answer for that. But
what is major economic loss?
Exactly.
$500 to one person means a whole lot different than $500 to another person.
I agree with you, and that would probably be a factual question for a jury, whether it was major economic loss, something that you would have to prove.
But I mean, here's the thing: like we have, all the theft statutes. Okay, it says if the value is between X and Y, it's this. If it's between Y and Z, it's this. It puts people on notice. So they're going to argue, how does that put me on notice? What is major economic damage? What is it?
Well, I mean, the standard for that is whether it's so unclear that it leaves an intelligent person uncertain as to what it is, right? Or it's void if it invites arbitrary or discriminatory enforcement. It doesn't seem that invites arbitrary or discriminatory enforcement, but an intelligent person knows what the word major is. I mean, it's not something that is difficult
It's
for people
very
to understand.
subjective.
It's important. It is.
No. We're going to talk about that. If one of the things that they're trying to say they put the defense on notice for is, we're charging you with this domestic terrorism because the actions that we're alleging you took against a group of individuals or infrastructure or whatever resulted in major economic loss. I want to know what you mean by major economic loss. Did I need to pick up some trash? Because someone threw a water bottle at a building? Is this like tens of thousands? Do I have to make insurance claims? Is this like did we have to shut down? That just expecting people to understand what major economic loss is, that's vague. That's vague. Like, what are we doing?
Big, it is large. And the reality is that under our statutes, we can't define every single word. I don't recall what word.
No, but you can put numbers on. I mean, because I think one of the arguments, and this might be an 18, I don't know. One of the allegations in count 2 is burning up an APD car.
Sure.
Okay. Police cars are not cheap.
Sounds
I'm
like
not
it's
trying to say
sassy.
that by any stretch of the imagination. But in the city that has a budget of $1 billion, where does major fall along that scale? Is one police car major, or do you have to take out a fleet of them? Is it a percentage of the budget? What is it? That's what their argument is.
And I understand that argument, but there's no case law that requires a discrete number in that area that suggests that there needs to be. And I agree
Discrete
with
or
you, they
at
are
all?
expensive. I've never priced them, but I would guess that they're probably in the 50,000 plus, maybe more than that with all
You
of
could
the
have included
equipment.
something
I
about
don't
it.
think 12 people in a box would say that's insubstantial in any way. I think everybody, no matter where you are, would say that that's a major economic loss. Now, but again,
I will respectfully disagree.
The-
It's a significant, but what is major? Like I said, when you have a governmental body that has a budget of $1 billion, and you're looking at something that's less than 1% of that, where does major fall?
You may disagree, Your Honor, but I think anybody that budgets in the government, no matter how big it is, would look at $50,000 and say that's a lot of money. Because if you walk in the door and say, "Can I have $50,000?" The second you start to get the word raise out, they're going to start laughing because it's a major amount of money. That's a lot of money. And it just is in the grand scheme of things. It's just a lot of money. And I'm using the term 50,000, just kind of popping it out there. But you see what I'm getting at. But we're not talking about,
I think there's a difference between insubstantial or substantial and major economic.
correct. And
Okay.
major economic, yeah, correct. I agree.
They're not synonymous, though. They don't mean the same thing. You can have a substantial loss, a substantial monetary loss without being.
Substantial, like think of a storm. Substantial storm to me is like it rains so hard and it's windy that some loose branches are falling down. Major storm makes me think power lines are falling. People are having issues with their roofs, like trees are completely falling down, crossing the road. Very different.
Being a major economic blow to a governmental entity. Can you not?
I mean, Judge, again, you don't have to define every single word for everybody here. And as we've been here the past couple of days, that's been the chief complaint of every defendant. What does this mean? What does that mean? And instead of taking one step back and going, well, that's what that means. We all know what it means. And so I understand that some people may always want to play the game of, well, what about this? What about that? What about this? What about that? Instead of taking a step back and going, what's the common sense meaning of this? And then I'll go, okay, that's what the common sense meaning is. Because that's what courtrooms are for, saying, what's the common sense meaning of this? Instead of playing this kind of whataboutism gotcha game that so many people have liked to play in this case, as opposed to just looking and going, what is a major economic loss? Okay,
Why would you make this argument when the judge said he just respectfully disagreed with this claim, your argument that major has a common sense meaning for what the state's saying it means? The judge said the specific $50,000 example, he disagrees that necessarily the common sense meaning could apply, or the description major could apply to that scenario. Why would you go off like this?
this a major economic loss, and let a jury figure that out. Because juries all the time are the fact finders. If we defined every single thing for a jury, every single word, juries almost wouldn't be necessary. Because if facts aren't in dispute, which
Well, wouldn't you have to define it in a jury charge for the jury?
I don't think
Yeah.
so. I really don't think so.
Okay.
I mean, a major economic loss is exactly what it sounds like. Major economic
It is up to
loss.
you, the enlightened conscience of the jury, to decide what major means.
We tell them every single day to do that.
Right.
Every single day to do that. And all the time, they ask, what does this mean? I mean, I know this court has, as long as it's been presiding, has had juries over and over say, what does this mean in the indictment, this word? And so many times the response is always the same. It's probably 40% of questions that the court gets. The other 50% being, can we have a transcript? And the other 10% just kind of being,
Can I see
random
this piece-
questions.
Can I see this piece of evidence?
Correct. And so so many times you have to look back at them and you know the answer, both parties know the answer, and you just kind of have to look at them and you may give them the same response every single time. And that is that you just have to use your common sense in defining these terms. And it's the same thing here. You just use your common sense to define the terms. But to turn back to the overbreadth, and I think I didn't lose my way by any means, but I want to get back to the overbreadth before I come back to the vagueness. No, it's quite all right. I think where I was I had reached the end of the word major economic loss. And then we have a second intent prong, which is really interesting in this statute. It's not a lot of times in a Georgia statute that you see that you have two separate prongs of intent. So this is, I don't think this is a legal term, but you might call it a double intent crime. You got to prove two different intents. And so you have your first intent, which is serious bodily harm, kill any individual, all those things I just listed, disable or destroy critical infrastructure, the state or government facility, public transportation system, when that results in major economic loss. But then we get to a second intent prong. And the second intent is intimidate the civilian population of this state or any of its political subdivisions, alter, change, or coerce the policy of the state government of this state and any of its political subdivisions by intimidation or coercion. And the third one is affect the conduct of the government of the state or any of its political subdivisions by use of destructive devices, assassination, or kidnapping. Now, I think it would be difficult for someone to argue that it's overbroad by including destructive devices, assassination, or kidnapping. Those are pretty specific and probably not covered by the First Amendment. So I'll just kind of focus on the first two prongs there. The first is intimidate the civilian population of the state or any of its political subdivisions. And I would point the court to the Georgia Supreme Court saying, indicating that if we're going to infringe on First Amendment rights, we've got to have a substantial reason for doing it. And if we take a look here at what they're talking about, intimidating civilian population of the state or any of its political subdivisions, what it's saying is, hey, you can't use violence and you can't have these very serious intents to do exactly that, which is infringe on somebody's First Amendment rights or cause them to be restrictive in their movements or make them do something or infringe on their freedom is basically what it is. It is, you can't infringe on someone's democratic rights to move around, to vote, to think, to speak, or anything like that. You can't set fire to things, to tell them to vote one way or do something or think a certain way while doing all that. You can't do that. So the second one is basically the same analysis, alter, change, coerce the policy of the government or the state, which is, of course, a democratic process. You elect these folks to make these decisions. And so you can't go in and shoot people, set fire to things with the intent of causing serious bodily harm, killing individuals, doing all of that to affect the the democratic process. You simply cannot do that. So while you may want to influence your elected officials, certainly you can do that. Letter writing campaigns, calling campaigns, protests, you can do all of that. You can do all of that. Of course, the government has the right to impose time, place, and manner restrictions on that. But you can do that. That is what the democratic process is for. You can run for office. You can be loud about it. You can wear T-shirts, bullhorns. You can do all of that. You can do all of that. The First Amendment protects every single bit of that, and it should protect.
You
every
can't
single
wear
bit of that. And mature
something. That's very interesting to say when we came out of the YSL trial and we heard how much you can't wear green or red or have an ESPN tattoo or have clothing that says Make America Slime Again. You can't have things that say slime or slat. So can we?
Society has a robust, protected First Amendment. But there's a line. And there's an old saying that my right to the freedom of speech ends at the tip of your nose, which means that as soon as you start doing violence, your First Amendment starts going away because you cannot do that. And that's what this is really getting at right here. And if I may turn to the vague standard, the standard for vagueness is it's unconstitutionally vague if it describes conduct in a manner so unclear that it leaves intelligent people uncertain as to the limits of the application, or if it's void for vagueness, if its terms invite arbitrary or discriminatory enforcement. There's a case, Helton versus the state. It's 624, and I've got it under the not my normal way of doing it, but 624 NE 2nd 499. It says Helton goes on to note that statutes which threaten to inhibit the exercise of constitutional rights or which impose criminal penalties are subject to greater scrutiny and less vagueness is tolerated in them than other laws. But the act of associating compatriots in crime is not a protected associational right. So even though that was there was a little bit about that, I wanted to go ahead and address it in the defendant's motion about associational rights. What the court is clearly saying there is you can associate all you want to. That's also protected just as much as speeches because it's kind of a form of speech in some ways. But what you can't do is commit crime together. We stop it there. Same thing. But when it comes to vagueness, if you look at section 220 of the domestic terrorism statute, it actually offers an awful lot of definitions for a lot of the things in the code. So I'm not going to go through every single one of them. But I will point out to the court that I think it goes through 5 or 6 of them. And I'm reaching for my computer because I'm going to
The count is on the screen, you guys.
move on
So
to the
Atlanta major
dual
economic
tracking
loss
of domestic
to
terrorism
PD vehicles, bank,
The
and
domestic
191
terrorism
Peach
statute
Street
was
Tower.
introduced in the House on February 21st. And Your Honor, I'm going to be honest with you, I'm going to be talking for a few minutes more up here as I go through this, just because I want to walk the court through what
That was
happened
short,
with
Gilmore.
it. It was perfectly passed, and it was correctly passed.
Because you're starting to speed up a little too. When people read, they speed up.
Okay,
There's no
I will slow down.
Yeah, just
I will do that.
Thank
And I'm going to give you a lot of dates as well, so I will go slow. February 21st.
And guys, so now he's shifting the argument to the second thing that we heard Stanley Cohen argue about is this, was this bill passed appropriately? Jumping over here, he argued specifically that under paragraph 12, rejected bills, no bill or resolution intended to have the effect of law, which shall have been rejected by either house, shall again be proposed during the same regular or special session under the same or any other title without the consent of 2/3 of the house by which the same was rejected. So Cohen says that this was not right. They violated this. So the bill wasn't properly passed. Let's hear the counter.
2017, the bill was introduced in the House of the state of Georgia. The next day, the 22nd, it was sent to the Public Safety and Homeland Security Committee. The next day, the 23rd, it was read in the House a second time.
Is it a House bill or Senate bill?
House bill.
It was a House bill?
Yes, it was House Bill 452.
Thank you. Second reading on the 23rd.
Yes.
Okay.
On March 3rd of 2017, it was favorably reported out of committee as substituted from the committee. So they made some changes in the committee here. They made some changes in the committee hearing and they reported it out as favorably substituted. That's not a failure.
Because there had never been a vote.
Correct.
There had been a second reading. There were changes made after the second reading.
Yes, in the committee, in the Public Safety and Homeland Security Committee.
See Cohen's head down here.
So they made some changes and then reported it out.
Correct.
Okay.
It hit the House floor the same day. It was read a third time and it passed the House.
It was also on March 3rd.
Yes, Your Honor.
Okay.
On March 6th of 2017. And just to be clear, that same day it was transmitted to the Senate. It says in-house, read third time, passed House to Senate. So it was transmitted to the Senate the same day.
Okay.
On February 6th of 2017,
March 6th.
I'm sorry, March 6th of 2017, my apologies.
All right.
It was assigned to the Senate Committee on Public Safety.
Okay.
9 days later, on March 15th, 2017, it was favorably reported as substituted out of the Public Safety Committee. So it made some changes and voted it out. On March 16th, it was read second time in the Senate. On March 28th, it was amended on the Senate floor. So no longer does it agree with the language of what came from the House. On the same day, it was read in the Senate a third time.
Same, hang on.
28th, Your Honor.
Thank you.
Welcome.
Third reading.
Yes. And on the same day, just so you don't have to write another date, it passed the Senate.
Okay.
And then on the same day, it goes back to the House. It says for concurrence, which this court I'm sure is aware means that the Senate sends it over and says, hey guys, we made some changes. You now have to vote.
Language has to match.
Exactly.
Okay.
So the House, and I think that this is a distinction. Some folks might think that this is a failure that the House did not, because what a lot of times happens is it goes to the House and the House does what's known as insist. They say, no, our version is better, so we're not going to agree with you, Senate. But that's not what happened here. On March 30th, the House concurred in the Senate amendment, but added their own amendments. So they said, yes, Senate, we like your version. This is good. We're going to add some more stuff to that. And then, of course, now it has to go back to the Senate where they say, hey, Senate, how about this version?
Mm-hmm.
And the Senate concurred with the additional amendments. So now you have matching bills in both.
So on March 30th, the House concurred with the Senate version and added more.
Yes,
Back to Senate same day.
same day, Your Honor.
Okay.
Yeah, on that day, it becomes eligible to go to the governor's desk.
So the Senate passed it the same day as well?
It did, yes.
Okay.
And then on April 7th, 2017, it was transmitted to the governor's office. And then it was signed by the governor on May 8th of 2017, and it became an act the same day.
Okay.
Do you wish for me to go through the 2023 amendment to it?
Well, first, let me ask Mr. Cohen. Mr. Cohen, you there?
I am here, Your Honor, thank you.
Okay, when you were talking to me about, well, the procedure and they didn't get the vote, were you talking about the 2017 initial passage of the bill? Or were you talking about either, I think it looks like there's an amendment in 23 and another one in 25. Are you talking
I'm
about one of the
talking-
amendments?
No, Judge, I'm talking about the 2017. What it chose to do after the arrest of the defendants is obviously irrelevant because it can't be applied retroactively.
Right. So your argument is with the initial 2017 passage. Now, you've heard the state outline the record that you were talking, you were going to get me anyway. You heard the state outline the process by which the bill flowed through the House and the Senate, correct?
I did, Judge.
And do you agree with the state's recitation of the record from the legislature?
Well, I agree with one thing the state said, and that was that different people may view this differently. And what the state would like to argue is that when the House says, this is no good, or we want to add this.
Wait, no. My question is, as he recited it, do you agree that it was introduced on February 21st?
Based on my record, yes, Judge.
Do you agree that it went to a House committee on the 22nd?
Again, based upon my notes in front of me, yes, Your Honor.
All right. Second reading in the House on the 23rd of February.
Correct.
On the 3rd, changes were made in the House committee, and then they reported it out on March 3rd.
Again, based on my records, yes, Judge.
Same day, March 3rd, third reading in the House. It passed the House and went over to the Senate.
Again, procedurally, that's correct, Judge.
Okay. And in case you haven't guessed, I'm going to go through every date that he gave me. March 6th, the Senate assigned it to their Public Safety Committee.
Correct, Judge.
All right. March 15th, changes were made and it was reported out of the Senate Public Safety Committee.
Correct, Your Honor.
And on the 16th, second reading in the Senate.
Correct.
All right. Amendments on the 28th, amendments were made on the Senate floor.
Correct.
Same day on the 28th, third reading in the Senate.
Correct.
And also on that day, it passed the Senate and then was sent back over to the House.
Correct, Judge.
On March 30th, the House concurred with the Senate version that they received, but also added more amendments. That's March 30th.
Well, Judge, my disagreement is with the word concurred. My view, my interpretation is that they said, no, we don't like this. You have to add the following, and added the following.
They made amendments,
Correct.
okay? And then they sent it back to the Senate,
Yes.
all right? The Senate passed on the same day, the Senate passed what they received from the House. You agree with that?
I do, Judge.
Okay. So it sounds like now that everybody agrees on the flow of this bill through the legislature, what your argument, correct me if I'm wrong, Mr. Cohen, is what the state asserts is a concurrence and then an addition of an amendment. You would categorize that as it failed and they sent it back with new stuff?
Correct.
That's your failure point?
No, my failure point, Judge, is, and again, I will get to the court. I apologize. It's my mistake. Some references that there was a vote down and a request that certain changes be made, and the changes were then made. And then it went to the Senate. It then
So
passed.
So you're saying before they concurred and added, they voted the Senate's version down?
Correct.
Mr. Fowler, do you have anything?
And the legislative history from Lexis that I'm looking at, and if the court pulls it up as well in its research, I see nothing in there with that. I'm happy to look at, there are a lot of things that can happen to a bill along the way. There are a lot of different things in Robert's rules as well, or I'm not sure that isn't encompassed by Robert's rules, to be honest with you. It may be something slightly different. But there are a lot of things that can happen in the meantime, such as introduction of amendments, all of that sort of stuff. So I'd like to see what Mr. Cohen has, but as far as I can tell from the legislative history, there is nothing in here that suggests that the bill was ever voted down.
Whisper,
Okay,
whisper,
here we go.
whisper.
And I'm gonna grab this up for y'all so everybody can see what I'm looking at.
I'm alone on the screen. Let me move myself.
This is the 2017 bill tracking on House Bill 452. And looks like the date we're having the arguments is around the events occurring on March 30th. House concurrence. Can you see this, Mr. Cohen?
I can, thank you, Judge.
Okay. House concurred in Senate amendments with additional amendments. And you're saying, Mr. Cohen, somewhere in there, there was a vote down?
Well, it's my record, and again, if it's mistaken, I apologize, Judge. I don't want to mislead the court. My research showed that there was a vote for reconsideration, and I will pull it out and send it to Your Honor and to the state as soon as possible today. That there was a 55% vote for reconsideration in the same session, according to notes that I have, instead of the 2/3 that were necessary. And that the reference to it as a
I need to see that.
No.
I understand that, Judge. My apologies. I will.
Because what I'm seeing and what the state has shown me so far doesn't reflect, that there was something that would trigger Article 3, Section 5, Paragraph 12, which is, and I don't know if you're willing to concede this, Mr. Fowler, but if it's somewhere in that process, as it bounced back and forth between the House and the Senate, it was voted down, in order to start from scratch, they would have to get the 2/3. If you're looking at,
I can see it from here, Your Honor.
okay.
Generally, I believe that the court is correct. I think there are some exceptions to that as well. This can get very complicated.
Your argument is it was never rejected.
Nope.
Therefore, the need for a 2/3 majority was never triggered. That's state's argument. Okay.
Correct.
And I don't have any evidence in front of me that it was rejected. That's my sticking point, Mr. Cohen.
I understand, Your Honor. Well, the House turned around and said, you can have this, but you're going to have to add X, Y, and Z in order for it to happen.
Well,
And
that's the legislative process. That's why,
I understand.
that the houses bounce back and forth and they have reconciliation committees and whatnot, because they've got to pass the same law in bicameral legislatures. Unless you're in Nebraska and you just do it because there's one. But from what I just read and the evidence I have before me, kind of went through the normal legislative process. Now, and I understand that's a separate and distinct argument from the overbreadth and the vagueness, et cetera, et cetera.
Found it. I think Cohen's right. Hold on. Oh my God, I have so many tabs open. Right? Is this it? Georgia House Bill 452, 2017, regular session. Look, here you go. That's 55%. 96 yays, 77 nays. So, let me link this in the chat. I think Stanley's right. He just, this vote, I didn't see it when I looked it up in Lexis, but I see it on Legiscan. So here's the vote. Dropping that in the chat. We'll see if, where is the stream? Back to our regularly scheduled programming.
But obviously, if they violated, the Article 3 paragraph, you don't have to get to the argument of overbreadth and vagueness because it was an illegally passed law. And I'm not seeing that as of yet.
Judge, and if I may.
Yeah.
Also refer the court to the actual the Georgia legislature website.
legis.ga.gov.
Yes, Your Honor. And instead of trying to search it through there, I can give you the entire URL that will get you straight there.
Okay, what comes after gov?
/legislation.
I think he's pulling it up. That's the same website, right?
Okay.
/50818. And I promise this is not this long.
Okay.
I don't know what we used to call it, but I guess we now call it hashtag.
No, that's not what my URL looks like.
15404, and that's the end.
We called it the pound sign.
That's what it was.
Pound sign 15404.
Yes, Your Honor.
And Mr. Cohen, I don't know if you're following on your computer, but I'll
I
make
am,
sure.
Judge.
Okay. I'm gonna share mine anyway. Oh, House vote. 403. Okay, so
403.
here's where the Senate on the 28th. That's the vote that sent it back to the House.
Wait, no. 452? What did it say about GBI? The text of the bill is different. Look at the top of it.
Agree with Senate submission.
That's not right. Hold on, pausing. A bill to be enacted entitled An Act to Amend Article 1 of Chapter 3 of Title 35 of OCGA relating to general provisions regarding the Georgia Bureau of Investigation so as to require the Bureau to publicly... I don't think this is the right data. Unless I'm missing something. And then, but the votes are there. They put the vote information incorrectly. I feel like this isn't the same bill. Maybe I'm lost.
Amendment 29. I'm not seeing anywhere where it got voted down.
House vote.
2/3.
I'm sorry, Judge.
That's okay. If you want me to click on something, tell me what you want me to click on.
No, I can see it, Judge. I'm reading through.
Because his 2/3
House
failure would
vote
have to be after the failure to
403,
concur.
House vote 404.
Nowhere was it voted down.
Oh, okay. Yep, that's the same one. Thanks, Peach
And that's
Milkshake.
true. The state's having to go under this version, not the 23 or the 25 amendment,
Mhm.
correct, Mr. Fowler?
That's correct, John. Well,
Let me know when you're done looking, Mr. Cohen.
I am looking, Judge.
All right. And for the record, nobody has any objection to the court using the legislative website for purposes of this hearing? Mr.
I have
Cohen?
not yet.
Okay, state.
no, we haven't, Judge. Just-
You're gonna let me take judicial notice of this? If that's what you want to call it?
We'll call it that. Yes, Your
Okay.
Honor.
Do I need to keep sharing this, Mr. Cohen, or can I take it down?
You can take it down, Judge.
All right. Okay, so any more evidence regarding the process of the passage of this bill
Nothing from the state, Your Honor. The state is concluded with its argument.
with all together or just as to the passage?
Yes, Your Honor, I've covered overbreadth, vagueness, and this passage. I believe that's everything that was argued.
Okay. Anything further from, well, Mr. Cohen, you get, it's your motion. You're going second anyway, but.
Yes, Judge, I would, apropos the discussion Your Honor had with the state over what is significant monetary damage in the context of a $1 billion budget versus a police car. I would urge the court that the state's argument as to the constitutionality under vagueness and overbreadth is an as applied. They keep drawing down to particular acts, allegations, facts, and injury. And our argument on the overbreadth is facially insufficient, and it violates the necessary notice to a citizen of Georgia or to a visitor. And again, while the state sort of poo-poos the idea or moves very quickly past the notion, when they come to such issues as coercion, intimidate, disable, affect, government, conduct, I would agree to the degree that the statute may say you can't kill someone. Sure, I'm not going to debate that. To the degree that the statute says you can't blow up a building, I would agree with that. Those are examples, and perhaps Mr. Fowler should have written the statute. We wouldn't be having this argument right now. But the one area where he gets down to is he talks about common sense. Someone knows you can't kill someone, you can't blow up a building. I agree. But when you come down to common sense and notice, there is no clear definition, or not even an attempt to narrow the definition of what it means to disable. Does that mean pull a wire out of a wall? Does it mean destroy it? What is critical? What is infrastructure? What is intimidate? What is alter? What is coercion? What is affect? And these are all what he reduces to sort of the second tier of the bill. It's not the second tier, it's part of the bill. And it produces all of these adjectives, these descriptions, these triggers that provide insufficient notice when it comes to speech, assembly, and association. And I understand that the state wants to go back to the particulars of a case, of a charge, but we're making a constitutional challenge on its face. The state does not address the Brandenburg concern. The state does not address the Rogan concern. The state does not address the three or the two constitutional cases that the Georgia Supreme Court spoke about. The state completely ignores the requirement that you have to give, yes, to some degree, I would concede, I know my kid can't go out and shoot someone or blow something up on its face, but that's not the test here. The test is the statute in itself. Does it pass constitutional muster? Does it leave too much open to debate? Does it give too much discretion to people in law enforcement and not enough specificity as to a citizen of the state as to what they can do or cannot do at a given time? You just can't parse out when dealing with speech, assembly, and association one narrow part of a statute and say, because this narrowly gives you a heads up that you shouldn't do X, that somehow swallows within it all those other adjectives, all those other undefined descriptions, all those other modifiers that mean nothing. I don't know, coercion, effect, intimidate. Mr. Fowler talks about the essence of democracy is voting. And we know that. The essence of democracy is to go to a public meeting. That's correct. Well, I can live in a democracy and intimidate someone else by what I'm saying, by what I'm wearing, by where I'm going. I could try to coerce my representative or a local or state representative by screaming or shouting or yelling or demonstrating. That's not the same thing. That's the problem with the statute. And that's why Brandenburg, and that's why Humanitarian Law Project, and that's why the state Supreme Court cases say you got to keep this narrow and focused so that citizens know with some clarity. And yes, there's obvious, but there's also that which you don't know, which is ambiguous. And then ultimately the problem here with these terms, it's left up to the police to describe. It's left up to the state to describe, to decide what's good, what's bad, what's acceptable, what's not. And that doesn't pass constitutional muster under the Georgia Constitution or the United States Constitution. Thank you, Judge.
Hold on. I'll look at that, but all protests / political speeches to affect the political outcome. That's the very nature of that speech. I think what Mr. Fowler, correct me if I'm wrong, Mr. Fowler, and he's fine with all that, but this is where he started talking about the double intent. You can do all of that, intimidate, coerce, that's fine. That's kind of the nature of political speech. You cannot use crime, which is the first intent, to do so. So the second part isn't illegal without the first. If you don't have the first intent, you don't get to the second one. Mr. Fowler, does that sound about right?
I agree. That's kind of the double intent prong I was referring to. It's an and, not an or.
Yeah,
Judge, I'm sorry.
that's okay. I don't mind it. You want to giggle at me? Go ahead.
Judge, I don't want to slip into an as intended. And I realize the RICO statute has been dropped or has been dismissed at this point. But when you take a look at the people's theory.
The court has found a procedural flaw in its methodology.
Yes, Judge. Yes. But just to go back to that, Your Honor, when you take a look at what, the people stand before the court and say, Judge, we're really limiting this to severe acts of violence. We're limiting the overt acts to all sorts of, obviously criminal activity, to weapons, to arson, to, things like that. But yet, when you take a look at what their allegation with the indictment was, it's filled with the very thing that Mr. Fowler says is protected activity. Promote, spread, recruit, narrate, word of mouth, take action, criticize, discuss, contact, delegitimize. So they want it both ways. They want to argue that we have a safety valve as law enforcement, and we get to keep this limited. And these are used as overt acts in furtherance of the conspiracy, and they were overt acts in furtherance of the RICO charge, and overt acts in terms of other charges. They want to say, no, Judge, law enforcement knows we can limit it to just robbing a bank, blowing up a building, or shooting someone. But yet they weave into their indictment, their charging documents, their arguments, their submissions, a whole host of peaceful, nonviolent, protected activity. And that, whether it's a double intent statute or not, is where the problem is, because you've got to give citizens enough notice out of the box that there's a line to cross. Brandenburg has it when it comes to the statute. This statute does not.
Okay, here's The count two, hang on. Count two was used as an overt act, wasn't it?
It was.
Okay. But there were special demurrers to other
Other defendants.
domestic terrorism charges that occurred in January.
January is.
Correct, yes.
And
Okay.
Marlon Cott's, three of
Um,
them, the overt act for three of them that involves a bank arson, gone.
And
They're not named in count two.
that was a special demurrer issue that we're now not going to get to, at least not this go round. But to the extent that the count two domestic terrorism is used as an overt act, because this motion is to preclude it as use of an overt act. The issue that the defense had with the March overt acts. The January one is the one that occurred in Fulton County. The overt acts from March of 2023 were not brought as individual counts because they occurred in DeKalb County in another jurisdiction. So to the extent, and so those two domestic terrorisms being used as an overt act might have different issues as far as this, a demur goes. Because while count two, the elements are set out, and I don't know if you were here Monday or Tuesday, I forget when we got into it, was part of the court's questioning surrounded defendants not being on notice of what those March domestic terrorism and what elements, how were they going to defend themselves against a domestic terrorism and arson charge that wasn't explained, or the elements weren't set forth in this indictment, either in a separate count, which it couldn't be, or in the overt act section. Whereas the domestic terrorism count two here that was used as an overt act, it is, the elements of it are spelled out in count two.
Tiny.
So domestic terrorism was used twice. Two separate domestic terrorism allegations were used as overt acts. They may not be similarly situated.
Another problem with the
because one
indictment.
occurred
We're going to pause. We're going to pause and look at that. So let's pull up this indictment, drop the link again in the chat so you can read it on your own time. So, and remember, if we get rid of count one and count three, a lot of this stuff in the indictment goes away. I don't know how they're going to fix that, but it is what it is, or what it will be. So obviously count one, you have racketeering, you have all these parties named. That's why we're going to shrink this case down if that sticks, if the appeals court lets the trial court decision stand. If we get to, let's start with the count. So let's go down to read the text of count 2. We've got the domestic terrorism. Now pay attention to the names. We have Nadia Greer, Madeline Fiola, Emily Murphy, Francis Carroll, and Ivan Ferguson. That's it. That's who's charged with count 2. So on the 21st day of January 2023, did attempt to commit the offense of arson in the first degree, a felony, with the intent to destroy and disable critical infrastructure, and such destruction and disabling would result in major economic loss, to wit, Atlanta Police Department vehicles, a bank, and the 191 Peachtree Tower. And said acts are intended to intimidate a political subdivision, to wit, the city of Atlanta, contrary to the laws of the state, the good order, peace, and dignity thereof. Now, I looked for all instances off screen of domestic terrorism to find what overt acts mentioned it, and which overt acts relate back to January 1st, the January 1st incident that's charged in that count. So let's go back down. Let's find, this is the 18th. So they're saying like, oh, they want to do this night of rage. It's different people. Hey, where's the text? Okay, there we go. Text loaded. So now these are the same 5 names that are being charged in count 2. So on or about January 21st, you have all 5 did join the Night of Rage in Atlanta and caused arson and property damage, and thereby committed the offense of domestic terrorism. This is an overt act in furtherance of the conspiracy. That's how Overt Act 152 is written. 153 is just Ivan Ferguson and Nadia Greer. Again, January 21st, 2023. They rode together to the Night of Rage in Atlanta. Inside the truck was a gas can, camping gear, and climbing gear. This is an overt act in furtherance of the conspiracy. 154, on or about January 21st, 2023, Ferguson and Nadia Greer rode together to the Night of Rage in Atlanta. Inside the truck was a... Is this duplicated? What? That's like word for word the same, I think, but okay. All right, so there's 153 and 154 are like the same thing. 155, on or about January 21st, Francis Carroll did possess a lighter and accelerant while attempting to break into 191 Peachtree Street in Atlanta and did commit the offense of domestic terrorism. This is an overt act in furtherance of the conspiracy. And then, on or about January 21st, Francis Carroll did possess a hammer while attempting to break into 191 Peachtree Street in Atlanta and did commit the offense of domestic terrorism. This is an overt act in furtherance of the conspiracy. And then the last one is Francis Carroll did possess spray paint while attempting to break into 191 Peachtree Street. The next stuff goes into stuff involving arson and a bank. We had a bank mentioned in count 2. But the way this is mentioned is 3 defendants that aren't charged in count 2. And we heard from Don Samuel, they were successful on a lot of their demurrers on their individual charges, where at the end of the day, Marlon Kotz, Adele McLean, and Savannah Patterson, from what I gather from Don Samuel, were only, as of yesterday, before yesterday, facing count 1. But this is where we get this property damage to a bank. They apparently publish on the Scenes blog claiming responsibility for damage to this bank in retaliation. Oh, oops. That was weird. Something was clickable here. But that can't apply because we're talking about these 5 individuals when it comes to the actual count. So I don't really understand how this count survives. I mean, what bank is there an overt act? Where is there a bank? We didn't read anything in the overt acts about them doing something to a bank. The other 3 aren't even named here. I mean, I don't know. It just seems really vague, if you ask me, but I'm not a lawyer. So let's see. Let's continue Judge Farmer's argument over here.
Hearing was spelled out in a lot more specificity.
Yeah, Dustin.
Versus the one that was not. So, and, I mean, it's not being used in as overt act anymore because count 1, you know, is, as you well know, the court's intent is to, set that aside. So my question is to you, you're arguing that, hey, they're arguing as applied, it's fine. You're arguing as it's written, it's not fine. Right, Mr. Cohen?
That's correct, Judge.
All right. You've given me Brandenburg, you've given me, state's given me Williams, Fielding, Helton. You've given me Brandenburg. You gave me a couple other ones, Mr. Cohen. You want to give them to me again?
Sure, Judge. I also gave you Ward Rock against racism, 491 US 781. I also gave you Humanitarian Law Project in 2010. Under Georgia law, I gave you State v.
Wait,
Miller.
can you just give me the sites, please?
Oh, I'm sorry, Judge. Let me,
Easiest way for me to find them.
okay, let me, Can I provide to your court clerk, as soon as we're done, the specific site in my argument page? I just
You,
put,
you can send an email to Mr. Fowler and Ms. Parsons, yes.
Judge, it's on
Okay.
page 12 of our.
On page 12, okay.
okay.
Do you want the site?
I'm
It's
sorry.
on page 12.
I also list Judge, State v. Miller, 260, Georgia 669, 1990. I list Cunningham v. State, 260, Georgia 827. I will send the sites for US v. Stevens, Sabra v. US, and NAACP v. Button. And then I will, Sessions and DeMaio, I will send you. I will also send you, I'll send them all, Judge. I've got the Johnson case.
Okay,
And finally, I have US v. Reagan, which is 314 US 513.
okay. Okay. All right, anything further from either side with regard to this?
Not from the state, Your Honor.
Mr. Cohen?
Not for me, Judge. I understand I have a colleague who wants to, I'm not.
Mr. Schwartz is, Mr. Schwartz is standing.
Judge, just a point of orientation. So it's Mr. Carroll's motion. We're going to supplement the motion with the voting record that we were talking about. But briefed pages 15 through 17 discusses it's the answer that Mr. Cohen was looking for regarding the down votes on Senate Bill 1. That's why we can't only look at this single page on 452. So we'll supplement with what you've asked for.
Thank you.
Okay. All right, nothing further on this one? Okay, Mr. Cohen, good luck getting proper ID.
I've got my appointment coming up and Judge, I'd love to see you in person. I hope I don't have to.
Fair enough. I get that a lot, no offense taken.
Thank you, Judge.
Thank
been an
you.
honor.
You're excused if you, or you can stay. It's up to you, sir.
Thank you, Judge.
Okay, let's take 10, and then you want to you guys want to come back and be heard on 18?
Just 18, yes, sir.
Okay. I need 10. Thanks.
I'm so confused.
Is that the prosecutor?
Oh, sorry.
All right, so they're gonna boot us out. What are we doing?
I think that's right.
An understatement by the prosecutor.
My general experience is they don't like it. You grab this when it pops up at the top.
I think it's.
Thank you. Appreciate it.
It seems so chaotic when there's multiple screens.
I don't really care. He said 10.
Yeah.
All right, so let's mute this. We'll jump ahead to see if they come back and.
Yeah, we went up to.
All right, we're all the way caught up, but prosecutor's coming back to the table, so.
Oh my gosh, that is cool. Thank you. I was so curious. I'm seriously gonna be singing. You say you want to radical.
Wait, is she singing?
The whole time.
Got some karaoke?
Do you have that motion printed by you?
Sabata, it was John Fowler that I think put the indictment together.
Do I have the motion?
So the other guy,
Yes.
The one
the
they're
other
about to
prosecutor?
continue to argue.
But I don't know if she was involved at that point or not.
Yeah, no, I didn't.
What is, what is?
Wait, because I didn't want to go down there.
But what you compare.
Whisper, whisper, whisper. And I did see for the Gregory King hearing, I did see Sylvia tweeted earlier. She's gonna go live in the afternoon after jury
Well, I'm not
selection.
worried about it.
But I
just
saw her
was
pop up
tired,
live now. Let
and
me
I
see if I
have a
can
super
see if.
stressful time
Oh,
get through it, and so I'm a little
oh, a little antsy.
amped, you know what I mean? Like, so I
Oh.
apologize.
No, it's okay.
I think, John,
Something about plea deals, but I don't know if
like,
it's
I left
for
15
Greg.
minutes
Let me
earlier
open it
every
and
day
see.
to get here, and I got here later every day.
Yeah, this morning it was awful. I could almost 50 minutes when I hit Waze. Because I always check Waze just to make sure it's not.
No,
really a weird
it's
road.
different
I
defendants.
always,
And it's a different road. No, like, oh, this is gonna be good. 52 minutes.
so it normally takes, so my normal plug it in to leave says 52 minutes.
Yeah.
It always takes a little longer than that. This, anyway, it doesn't matter. The point is I left yesterday 15 minutes earlier than I'd left the day before.
Right.
Today I left 30 minutes earlier than the first day, and I got here 40 minutes later than I did. So I can't, oh, I'm sorry.
No, you're fine.
I was also up late last night. I really think when we're back in here, we need to ask about muting this when we're on break,
Yeah,
because they're muting it on.
yeah.
If it wasn't. muted,
Are they
I'd show
muting
you.
it?
Doesn't matter, but.
Is that guy filming the ceiling?
I was back there doing.
I think I'm saying I'm leaving alone.
Okay. Okay, well, I got it. I'm okay.
It's like being broadcast. Everybody's business is being broadcast. Or maybe I'm overhearing from Sylvia's court, the medication
Can I
thing.
see the motion? Is it in?
If it's in there.
And speaking of motions, this was and remember, a lot of these motions were filed by the defense a long time ago, but state just didn't really respond. But this was the motion regarding like the authority of the prosecutor. Did they have jurisdiction? Did they have authorization to bring these charges forward? From 2023. Yeah, this is the court feed. So this is from Judge Kevin Farmer's channel. So they're not muting it, but if they use the same mics that they had in Glanville/Whitaker's courtroom, they should have the button to mute.
Do you know what items this is for me?
Huh.
What items?
My bag is closest to you, the generator is close to there.
Right here.
Yeah.
I need him to come with this man, because they cannot, that's a safety net, they can't put it right here. I told you. There's been everybody can see. And I'd be ready.
Yeah, you want me to fight it?
I don't even know who it is.
It's the guy who walked in later.
I feel nosy.
You don't know what it's.
I'll say the only other thing I have on my mind that I want to look at, maybe go live and talk about it if you guys are interested. It's too long to blurb right now. And that's Joe Tacopina in the Fat Joe case responding to Tyrone Blackburn. So I think it's going to be good attorney squabbling on paper.
So this is the thing, because all of you are right here.
Welcome back, Factual Lie.
Imagine I put it right there, because all are right here.
Well, you might as well fire that up, Nick. Probably get through like the intro cinematics by the time they get back. Where is it? I've got a video for this. Takapina.
It's in Hong.
I don't know the specifics of the car. Because if we go to the indictment, you know, it's obviously mentioned in count 2 and it says vehicles. And then if we search, there's only 3 instances of the word vehicle. So this one is unrelated, different defendant, different incident. The only other mention, we have Francis Carroll, which that's one of the ones mentioned. Then Geneva Tilbury and Nicholas Olson, December 13th, did damage an Atlanta Police Department vehicle. So I don't see vehicle damage mentioned in any of the overt acts. That would be this January 21st, 2023 date. And again, even if this was the same thing, it's December 13th. They just said did damage. So, I don't know. Oh, case. Sorry, if you meant case, that's really funny because there's a whole dispute about is there specificity enough for the defense to know what they should be on notice for in relation to what's alleged under count 2 here to defend these individuals against the claim that, you know, they committed domestic terrorism, attempted arson against police department vehicles. And this is the only information they get because there's nothing else relating to this date and vehicles in the indictment. But if you meant case, so it's really funny. So this is brought by the Attorney General, and we'll mute this. This was brought by Attorney General, well, I guess you guys couldn't hear that, but I could. Attorney General Chris Carr, Georgia Attorney General, brings us indictment, 61 defendants. Really, it's supposed to be a RICO case. As of yesterday, that's in limbo because the judge is ready to get rid of count 1, racketeering, and also count 3, arson. State's going to appeal that decision, so who knows. But if it sticks, that will whittle this case down to the 5 individuals named in the remaining count 2. Judge didn't rule on any of the general and special demurrer issues argued on the other counts or overall about the indictment that were argued yesterday. But yesterday and the day before. But he's hearing some arguments on this count 2 in case whatever decision comes from this appeals process, what do we do moving forward? Whether we only have count 2 or if it's reversed and we have everything back on the table again. What do we do about this count 2? We'll let you make the record. And now they're trying to figure out the specificity. So if we look at the indictment as a whole, it's a few years spanning where the state is alleging that these individuals committed different types of crimes or offenses in furtherance of an enterprise. The enterprise is supposed to be defend the Atlanta forest. But they name a bunch of other organizations, and in some of the overt acts, they say that the other organization is the entity associated with whatever's being done by different individuals. So there's issues there. There's issues there. But it all stems down to all of these protests. They mentioned protests against George Floyd, Rayshard Brooks, but this indictment is supposed to say that the purpose of this enterprise is to defend the deforestation and militarization that comes with the construction of a police training facility in Atlanta, which is being called Cop City. So that's why we're calling it the Stop Cop City RICO. And these are individuals that, quite frankly, to me, say somebody did commit arson, did a thing. Seems like maybe that's one person and you should have charged them for that thing. But the way this whole indictment is written, it's just like they wanted to rope up anybody that they could catch as being present in some way, or maybe communicated with somebody, or that they think may have been the one that wrote an anonymous blog post about an incident that took place in Portland, Oregon. And it's all over the place. It's all over the place. And I think that's why we're having the judge say, like, yeah, this is kind of crazy. The issue he ruled on was that the Attorney General didn't have authority to bring counts 1 and 3 forward, that it really should have been through the permission of a district attorney at the county level. But they wrote this indictment in such a messy way, I think, because they want to be able to charge counts against certain people, and they can't specify what that person did in a Georgia county where they would have jurisdiction. But they want to inflame the grand jurors and then the jury through trial with all these mentions of different protests and major scary things that happened around the country. So to me, it seems like they want to give the image that these 61 individuals are burning down cities when we look at what's remaining, somebody had the possession of a lighter and spray paint for one of them. And then for the remaining 4, they're in a vehicle with camping gear in the trunk. Is that what we're really going to be left with? With something that, I mean, just imagine the time and resources that have been wasted here. We had this come down the 11th day of March. Well, no, wait, when was this signed? Maybe it's at the top. Okay, so this goes all the way back. This indictment, they presented it. They started the grand jury hearing the July 2023 term. This is dated August 29th, 2023. So all the investigatory resources that got us to this point and everything that followed after, a whole hot mess. This was Fowler that did the, there you go. So there's John Fowler. So that's the guy we've seen arguing for the state. It's just a mess. It's just a mess. So sorry I don't have clarity, but that's the problem that we're dealing with. We don't have the judge back at the bench, but we have some of the defense attorney. Well, one of the defense attorneys. 2 maybe, right? There's an elbow over here. This guy's scooting in his rolly chair. Yeah, and then there were a bunch of money laundering charges, like actual counts for like amounts of like $20, $50 for reimbursement for food. And furtherance of the conspiracy and furtherance of the enterprise. It just seems stupid. If somebody burned something down, allege that, say what burned, say when it was burned, name the person, bring that case. Well, just philosophically speaking, you know, social movements, one of the biggest things that can make a social movement fail is if the social movement, if their tenants do something that the general public isn't going to sympathize with.
Thank you all.
The reverse of that is when you have the government over prosecuting.
Okay.
So what they're doing here is, I mean, there's a diverse group of people that are interested in watching what the government's trying to do against freedom of speech, and what looks like a huge constitutional violation, bringing this case together. What a huge L for the state.
Let me ask you, who's going to be arguing for, oh, we got a new face at table. Who's going to be arguing motion 18?
Jonathan Sidney for the defense.
Is that you, sir?
That is, Your Honor.
Okay, and what name again, sir?
John, Your Honor, represent Victor Cortez.
Sid, just SID.
SIDNEY, City, sir.
Oh, Sydney, okay. Let me ask you this, purely timekeeping. It's 11:30. It's early for lunch, but if this is gonna go till 12:45, nobody wants to be hangry themselves and nobody wants a hangry judge. So do you guys want to break and come back at 12:30, or do you want to just push through? How long do you anticipate your argument being, Mr. Sydney? I don't have a dog in the fight.
Judge, I don't know obviously what the court's gonna ask, but I don't plan on taking more than about 5 to 10 minutes to present argument.
Oh, okay.
Mine's short as well. I think we've addressed a lot of the issues already, so I'm just gonna kind of maybe clean a couple things up.
Okay.
Now, maybe we can all-
That's what I needed to hear. Okay, Mr. Sidney, you're up. Podium, please.
Thank you, Your Honor. Judge, I'm cutting some of my introductory remarks because I think some of these issues were raised in the last argument. I think the court's well aware of the standards governing vagueness, and I think the court, from what I could tell from your questions, has an intuitive understanding of some of the problems with the issue that I'm going to focus on, which is major economic loss. We're not waiving any other issues we've raised in our brief. We stand on our briefing as to that, but I did intend to focus our argument on major economic loss prong today. Judge, I think there is one framing case, United States versus Williams, that indicates, I think has some pretty instructive language here. A statute should be struck down as unconstitutionally vague where the culpability of a defendant's conduct is based on language.
Oh, yeah.
Sorry about that.
So you heard me say, when people start to read, they start to really pick up steam.
Slow it down a bit, Judge. Judge, this is at page 5 of our brief too, if the court needs to reference it. Statutory language is impermissible when it calls for a, quote, wholly subjective judgment without statutory definition, narrowing context, or settled legal meaning. And the reason why we're starting here is because I think it's the most straightforward and simple problem with the statute, in my view. Major economic loss is not a term that's defined. It's not defined by statute. It's not defined by narrowing context. It's not defined by settled legal meaning. Judge, if you perform a Lexis or Westlaw search for major economic loss in the state of Georgia, you're not going to turn up any cases. There's not something that we can look to the case law for guidance on here. As a result, Your Honor, both on its face and as applied to Mr. Carroll and his co-defendants, this is not a statute that provides fair warning that specific conduct is prohibited or sufficient specificity so as to not encourage arbitrary and discriminatory enforcement, because nobody can really tell you what it means to be major. I do want to focus the court's attention on 2 specific controlling authorities that we think are virtually dispositive of this issue. They're both cited in the brief. I do have copies if the court wants physical copies to review. Okay. So first, Judge, is the Johnson case, State versus Johnson, I should be clear. There's a federal Johnson case too. That's the case cited at pages 12 to 13 of the brief, 270 GA 111. It's a 1998 Georgia Supreme Court case. There, the defendant brought a challenge to a statute that required a driver who's involved in a highway accident to move their vehicle unless the accident involved injury, death, or, quote, extensive property damage. And that was the prong that was at issue in the Johnson case. The court rejected the statute, said extensive means different things to different people. So too with major economic loss, Judge. These are synonyms, extensive and major. So the court in Johnson says that defining extensive involves answering a series of questions. Does the term depend on the extent of physical damage to a vehicle? If so, what percentage? What type of damage? Does this depend on the cost of repair? If so, how much cost is needed to make the repair, the damage extensive? And because reasonable people are going to differ in their answers to these questions, the Georgia Supreme Court struck down the statute, finds it unconstitutionally vague. And we really, Judge, we have a similar set of questions here. Some of them are laid out in our brief. I'm not going to repeat those here, but there's some more questions that aren't answered. First, and this goes to Your Honor's point earlier, what's the initial reference point for determining whether an economic loss is major? We could be talking about the city of Atlanta. It's got a $2.5 billion budget. Maybe it's the state of Georgia. That's got a $36 billion a year budget. And then once we take that unknown and undefined reference point into account, how do we go from there and determine whether the loss is major? Is it a percentage of the annual budget? Is it some other metric? And more fundamentally, Judge, how do we even think about how to answer these questions? What's the guidance on that? Here, exactly as in Johnson, reasonable people are going to differ in their approach, and the statute is not providing us with any answers. And the answers are not for the court, Mr. Fowler, or myself to speculate on. I do want to quote a little bit, try and keep it slow, Judge, but it's from a case cited in our brief. It's the United States versus Davis case. It's a 2019 Supreme Court case. There was written at the beginning of the opinion, in our constitutional order, a vague law is no law at all. And vague laws hand off the legislature's responsibility for defining criminal behavior to unelected prosecutors and judges. When Congress passes a vague law, the role of the courts under our Constitution is not to fashion a new clear law to take its place, but to take the law's ability and invite Congress to try again. So it's a separation of powers problem issue, Judge, not just a fair notice problem. The second authority, Judge, that we think really compels dismissal in this case, it's the Cohen grocery case. That's a 1921 Supreme Court case. That's also cited at pages 12 to 11 of the brief. It's a century-plus old precedent, but it's actually been explicitly reaffirmed recently. It was cited extensively in the other Johnson case, Johnson versus United States. That's the 2015 Supreme Court case at page 12 of our brief. In Cohen grocery, Judge, there SCOTUS held that there was a law. It prohibited grocers from charging an unjust or unreasonable rate. SCOTUS said that's void for vagueness. There's no ascertainable standard of guilt. We don't know what that means. And same thing here, Judge. We've got a major economic loss element, just like the unjust or unreasonable rate element, just like the extensive property damage element. All of these terms, they criminalize activity based on whether a subjective and indeterminate threshold of damage has been crossed. The court, respectfully, Your Honor, you took my example earlier. The legislature certainly would not have passed a statute distinguishing misdemeanor and felony theft based on whether the theft is major, because you can't delegate that legislative determination to an unelected judge, respectfully, or a jury, or a prosecutor, or a law enforcement officer.
I'm an elected judge.
Elected judge. Sorry, Your Honor, my mistake. Legislature also wouldn't pass a statute saying that possession of drugs is a misdemeanor unless it's major. Or I guess we could use Mr. Fowler's words. When Mr. Fowler tried to define major, he said, it's big, it's important, it's large. I don't think anyone would think it's reasonable to have a law that says possession of drugs is a misdemeanor unless the possession is big or important or large. You know, that's fails the vagueness test, and this statute fails for the same reason. And unless Your Honor has questions at this time, I'd sit down.
Nope.
I'm not going to waste the court's time. The court's already heard the argument on this. And so if the court has any questions, I'm happy to answer them. But we already kind of went down the vagueness. Sounded like the same argument to me. And I don't mean disrespect to Mr. Sidney when I say it sounds like the same argument. I don't think my tone was good when I said that. So with that in mind, same argument I had earlier, Judge.
Okay. You're not getting a ruling from the bench on this one, sorry. Take this one under advisement. Do we have anything else going today? Did you want to get to, this is it for today?
We think it makes sense to stop here.
Okay.
Just an administrative issue, hopefully an issue of 1 out of 10 difficulty. Does the court intend to, once the court rules on the constitutionality of this statute, does the court intend to issue a certificate on that as well?
Oh, yes, it's all.
Because of the way that one is constitutional and the other one is statutory interpretation, would the court be willing to issue 2 different certificates just in case one has to go all the way up first and the second one goes halfway? I don't say halfway, as though it's only halfway, but the court knows what I mean.
The intermediate
There we
appellate
go.
court,
That's
there
the
you
word
go.
I'm looking
I'm happy to do
for. I
that.
appreciate that.
Yeah,
Judge.
just-
Thank you.
yeah. Any objection from the defense on that one?
I mean, it's the Supreme Court's discretion. They're gonna, whether it's 2 or 1, they'll decide if they want to take both. They have to take the second.
Well, but he's also talking about the Court of Appeals.
That's what I mean.
Yeah.
It
You
it
said the
doesn't,
Supreme
I don't
Court.
think it makes a difference. No objection.
Okay, there you go. That's the answer I was looking for. If that's all,
Judge, do you want to discuss discovery?
No. Thank you.
Alrighty. So, what do you want to do, chat? Also, I dropped it in the chat. Sylvia and Dizzy posted updates on Gregory King, Young Thug's brother. He's taking a plea, and so are his co-defendants. Obviously, I'm not able to watch that plea hearing. Sylvia's still streaming it live right now, but the deets are 10 to 20 years for the sentence with 10 to serve, and he'll get credit for time served. So that's like, I don't know, 2-3 years that'll be chopped off. So taking the deal on that one. All right, and they're cutting us out, I think. Why is his tie to get? Let me move myself. He's got like the Dilbert tie. It's like stuck. So yeah, let me get Sylvia's link. Is this actually ending, or what are they doing?
The court took up yesterday, right? We don't even have to
All
look
right,
at the
so they ended
indictment
this
to deal.
feed. So this seems like they're gonna come back, but on a new stream. All right, never mind. All right, so I was reading, it's Atlanta Community Press Collective said not yet. The court will resume shortly, but I think that was from the break that they just took like 10 minutes ago. So I think the stream is ended for sure. And then Sylvia's stream. Yeah, so I'm not sure what's going to happen with that then, AutoDoc. I mean, I guess they got to get the paperwork showing it to the judge for the judge to make a decision. But otherwise, it seems like it was going to stick to, you know, is it enough to say that, well, we want additional amendments and then we agree with the amendments? Does that really count as it being voted down? No. So I don't know if Jim is awake yet. I was going to see if he was going to say if he was going live at all today. Jim, Happily Angry Lawyer, mentions even though he's reviewed the indictment already, especially with everything that's gone down this week, he might be interested in going through the indictment again. So that's possibly something he'll talk about if he ends up doing a live, if he has the time to do so later today. He might also want to talk about the Gregory King case, especially now that there's going to be a resolution there. And then, yeah, I don't see anything scheduled on his channel or anything. And then as far as redirects, do you guys want to go watch the co-defendants in the Gregory King case? Because I think that plea hearing is still ongoing. We'll just hop to another Fulton County courtroom. If you really only cared to hear, and they might be taking similar pleas, it might just kind of be the same thing from here. But there is, let's see, other options. Dolly has Judge Simpson and Courtroom Roulette, so he's hopping around different courts. Recovery Addict is doing Ohio versus Brandon Reefers. Alternate Corner is doing the Samantha Krebs case, the Wisconsin case. Everything else is upcoming. I thought Classy, let's see, Classy Beats might be about to start up. And he'll be talking about the Bortland plea. Yeah, if you guys want to, he's going to be talking about the Bortland plea And then also what's going on with Wendy Adelson, and looking at Jeff Lacosse's interview. So those are the options I see that are either live right now or Class C scheduled to start 2 minutes ago. So, oh, and it's bad audio. Nick's gonna go play video games. And then Autodoc says Bill 458 was never voted down, but Senate Bill 1 was much earlier and was the same bill. But if one was in the House and the other one in Senate, can't they both try and make amendments to each other's? So, yeah, I think everybody is waiting for the Wendy news. Especially, like, she really said on the stand, oh, the state's not going to arrest me. It's a bold thing to say on the stand. And that quote may live in infamy. We'll have to see. Good to see you, Doug. Kelly, thanks for becoming a member. And yeah, do you guys want to do that? You guys want to go check out? I know everyone has a bunch of questions about the Bortland plea. And when we talked about it yesterday, that was before. Today, there's a statement from the prosecutor that he is going to give a statement on everything that he knows. Not that he'll testify at trial, but he's going to proffer. He's going to give a statement to the state. And then yesterday, the attorney is like, he's not cooperating with the state. So I think Classy's going to go over all of the different coverage that happened throughout the evening yesterday. So yeah, definitely a sweet plea deal. And think about that. So we have Greg. We're hearing that Gregory King takes his plea for, he's going to do 10 to 20 years, 10 to serve, credit for time served. But we heard that they were ready to drop a lot of the charges against him, like 19 out of the 21. But that's still the deal that he's getting. Now, Bortland, who was facing 2 murder counts, they drop everything except, what did he get? Accessory after the fact. Covering up. He got 2 counts. Sweet, sweet plea deal. So I think we'll do that. We'll redirect. Classy will give a roundabout view of all the stories that are going on. His chat is great. If you've never hung out over there, you'll love it over there. You'll see a bunch of familiar faces. Did I save the redirect? Let me make sure. Because if you don't hit the save button, you'll tell people, oh, we're redirecting, and then nobody gets sent anywhere. All right, so that is saved. So we'll go over there. Any updates with the Cop City stuff, I'll either do a quick video, community post, or pop back live if it's something that's going on a little bit longer. But other than that, guys, good to see everybody. Big thank you to everyone that became a member, and J Money again for gifting. That's super generous to do the 20 gifts for you guys, turning you green. And we're going to go hear more about what Classy's talking about this morning. So see you then. See you next time, whatever the case may be. Bye, guys.